Welcome to Respecting Religion, a BJC podcast series where we look at religion, the law, and what's at stake for faith freedom today. I'm Amanda Tyler.
And I'm Holly Holman. It's good to be with you, Amanda.
It is. We are recording this on Wednesday, November the 12th, and eagerly awaiting a vote in the U.S. House of Representatives. They are back to work for the first time in almost 2 months. Hard to believe.
Traffic picked up a bit today.
Yeah, and so many mixed emotions, but ending a shutdown and getting benefits back to the people who need them most and getting paychecks back to federal workers who have been working without pay for so long. These are good outcomes to what's happening. And I know, especially for people working in the D.C. area, but also across the country, that we are ready to get back to a more normalcy, although, again, nothing is normal right now, Holly.
That's right. But that is, I think, a step in the right direction. And as you know, it will help many, many people. So today on Respecting Religion, we're going to review the Supreme Court's oral arguments earlier this week in a religious liberty case that involves a federal statute designed to protect the religious freedom rights of prisoners. Yes, you heard that right. Religious freedom is such an important aspect of our country's legal tradition that when the U.S. Supreme Court failed to find it sufficiently protected by the First Amendment in a case, Congress passed a law. They passed the Religious Freedom Restoration Act, and then later one aimed particularly at protecting individuals in government custody, including prisoners. And this week, the U.S. Supreme Court heard arguments about that one such law, the Religious Land Use and Institutionalized Persons Act of 2000, and particularly what remedies are available when that law is violated.
That's right, Holly. We gave a short preview of this case earlier in this season of Respecting Religion in episode 1. And today we wanted to review what we heard at oral arguments this week in the case of Landor versus Louisiana Department of Corrections. The case has not received the kind of attention that religion cases often do, and also as much attention as many other cases on the court's docket this year. And, as we've pointed out in the past, this is not one that is a divisive case among the groups that typically engage in religious freedom advocacy in the courts. But it turns out, Holly, that doesn't mean it was an easy case for the 9 justices on the U.S. Supreme Court. So let's remind our listeners first a little bit about what this case is about.
Yeah, the Landor case, Landor versus Louisiana Department of Corrections, is about what remedies are available under that federal statute that protects religious freedom, the Religious Land Use and Institutionalized Persons Act. What remedies are available when there is a violation? It's an appeal from lower court rulings that found that although a former prisoner in Louisiana, Mr. Damon Landor, had proven the statutory violation, the evidence was kind of undisputed, really based on horrible treatment, the court below held that he was not entitled to the relief that he sought, and that was money damages against the individuals who did this to him. And the court, when it granted certiorari back in June, said this: Congress has enacted 2 sister statutes to protect religious exercise, the Religious Freedom Restoration Act of 1993, RFRA, as we know, and the Religious Land Use and Institutionalized Persons Act of 2000, RLUIPA. And in Tanzan versus Tanvir, a case the court decided in 2020, the court held that an individual may sue a government official in his individual capacity for damages for violations of RFRA. Well, RLUIPA has the same kind of language. The relevant language is identical. So the question presented in the Landor case is whether an individual may sue a government official in his individual capacity for damages for violation of RLUIPA. Under the statute, people incarcerated in state prisons receiving federal funding, can bring a claim to defend their religious exercise rights and, quote, obtain appropriate relief against a government, close quote. So that's the statutory language in both statutes. And Mr. Landor, represented by private counsel, and we, as a friend of the court, argued that that language clearly authorized damages against the officials in their individual capacities. As I said, the court has already held that that language provides individual damages in the RFRA context, and we say that the same result is required here. Why is this case so important to us? Well, as friends of BJC know, we supported this same position in that earlier 2020 case. As we say in our statement of interest in an amicus brief that we filed, BJC, this organization, Amanda, that we work for, that's been around long before us, we have vigorously supported both the free exercise of religion and freedom from religious establishments for more than 8 decades. BJC chaired the Coalition for the Free Exercise of Religion, which specifically urged Congress to pass RFRA and RLUIPA, and we've continued to defend the constitutionality and applicability of statutes in numerous cases before the courts. And so we were really glad to join an amicus brief in this case in support of Mr. Landor.
And we will link to the brief, which really has a very broad coalition of groups that support religious freedom, but often are on opposing sides when those cases come to the court. And so we were really pleased to be part of this broad coalition. A coalition that mirrored in many ways, maybe not the same exact groups, but the breadth of the coalition that helped pass the original Religious Freedom Restoration Act and RLUIPA in 1993 and 2000, respectively. And I think at many points, Holly, we've talked about how that broad coalition has really diverged in many ways in the past 25 years. And so it was good to come back together on this brief in support of Mr. Landor's case, and particularly his right to have a suit for money damages from the state prison officials who violated his constitutional rights.
Yeah, it's perhaps not surprising that the coalition would splinter as the law develops and is applied in different ways because, people have a lot of different interests and opinions about religious claims. But at the heart, the coalition was together in saying we need these protection for everyone, and the statutes should be written in a way that everyone has the chance, right, the opportunity to bring a claim. And that's really what's so important about that coalition, and that this kind of effort could come back together for this, because that's what this case is about. What does the statute provide? How should it be interpreted so that it is fair and does the work that it's supposed to do? And in this case, there is no question about the particular practice or issue at the heart of the case. As we'll talk about the facts, they are, that was not in question, but simply, how does then the person whose rights have been violated then get relief? For us at BJC, the relationship between these two federal statutes is a big part of this case. It was a big part of the brief that we're on. We just want to make sure that the statute is interpreted to do what it's intended to do. And in this case, the particular relief sought is necessary. Mr. Landor could not seek prospective relief based on the violations that happened to him, the way he was treated. That means he can't, stop this. He can't say, don't, stop some practice that's ongoing. His claim was moot because his sentence ended shortly after what happened to him. He was released, and really his sole chance for effective relief was to seek damages from the offending officials in their individual capacities.
And just a very brief review of what happened to Mr. Landor here. And we're going to get into playing some clips from the argument shortly. But when he had been serving a sentence, he had been in a couple of different facilities. When he was transferred to the particular facility and prison in question here, he, as a devout Rastafarian who wears dreadlocks as a part of practicing his faith, he was prepared. He knew that he had a right under RLUIPA to have his hair in these dreadlocks, and he brought. And again, this is the incredible piece to me. He actually brought a copy of the opinion showing the new officials, not taking for granted that they would know the law, but brought to make sure that they would know it. And even after showing that he had a right to it, they violently not only threw the copy of the court decision in the trash, but then shaved his head bald in violation of his rights. And so, the relief here, the question again is not whether his rights were violated. The relief matters. The relief as a deterrent effect for other officials who might be in a similar position, and also just to be sure that his rights can't be continually violated from being transferred from prison to prison. Holly, you were actually at the court this week to hear oral arguments in this case. I listened in on the live stream from the court from my desk in Dallas, and was very interested in. And I think my first impression was just how into and engaged in the argument these justices were, and how there were pretty clear divisions between them almost from the very beginning, that I could tell very early on that this was not going to be an easy case for the court, and particularly some pretty aggressive and incisive questioning from justices, particularly of the attorney who was representing Mr. Landor. So what were some of your impressions from being inside, in person in the court?
Yeah, well, I always like to get in the courtroom if I can. Our offices are close to the court, and I can sit with the Supreme Court bar members, and you can pick up on some of the feel for the case and the justices being there. This was a little different. It wasn't super crowded as far as long lines getting into in the courtroom, although it was full. So I think that's just reflective of there not being a high degree of public interest. But it was still lively. I was sitting in the lawyer section, this time on the right-hand side, closest to where Justice Jackson sits, and it's about on the third row, right behind the SG and the team of lawyers from that office who were there supporting the young attorney, Libby Baird. From that office argued alongside the petitioner's counsel, and I was beside where the guests of the justices are, and there were only about a half dozen or so there. And going in, I was just very interested in and hopeful for all the for Mr. Landor, with all the support he had, many amicus briefs filed on his side, and I was really just struck how all of the justices were tuned in and seemed to be really kind of struggling, thinking through this case, animated, only a couple of them. A couple of times did it feel kind of hostile, but generally just highly engaged. I think it was a really well-argued case for Petitioner Landor. We had the private counsel, Zach Tripp, and from the SG's office, Libby Baird, and then for Louisiana Attorney General's office, Benjamin Aguinagua. It was much longer than I thought it would be. And just from the outset, I was struck at how different the understandings were about what is necessary in order to provide the remedy that was being sought in this case. As usual, the court's looking at the text of the statute, and there was a lot of debate about is the text, is it valid? Is it enough? What's required to have the kind of remedy that Mr. Landor was seeking?
And, I was pretty surprised at how controversial it was, because as we've noted in the Tanzan case from just 5 years ago, the justices did uphold the availability of monetary damages in the context of Religious Freedom Restoration Act, and in the context of federal prisons. And so what is different here is it is a state prison case, and it is under particularly the authority of RLUIPA. And so this is where it gets a little more technical on the statutory side, that there was a lot of conversation at the argument about the spending clause power of Congress. And just quick, Government 101 review of the Constitution. Congress has limited powers, and they can only enact statutes under limited authority. And one of those authority is under the spending clause, basically when Congress spends money, that they can attach certain requirements to that spending to the states. And in this case, the link is the federal funding that might go to state prisons, and that with that funding comes certain requirements. In this case, requirements to abide by the statute, RLUIPA. And so very early on, we saw that this question of what does the spending clause allow and what does it require in terms of notice, that seemed to be a very central argument that was going on in the courtroom.
So with that, let's play the opening clip from petitioner's side. Again, Zach Tripp representing Mr. Landor.
It is undisputed that my client has alleged an assault that is just brazenly illegal. He was at respondents' mercy in federally funded custody when he handed them a copy of a controlling precedent holding that RLUIPA protected his right to keep his hair long. They threw it away, handcuffed him to a chair, and shaved him bald. It is the poster child for a RLUIPA violation, and the law provides a damages remedy. This is spending legislation, so I want to go right to that and make 2 points about clarity and constitutionality. So first, on clarity, the whole point of this law is to restore pre-Smith rights and remedies. Damages were available before Smith. They're available under RFRA, and RLUIPA uses identical language. They're like twins separated at birth. They clearly mean the same thing. The individual capacity action is especially clear. On the face of the statute, it expressly authorizes suit against an official or any other person acting under color of state law. That obviously means individual capacity. And then once you see there's an individual capacity action, the rest of it falls into line because damages, the whole point of individual capacity is to have damages. Damages are presumptively available against a non-sovereign, and without damages, officials can literally treat the law like garbage. On constitutionality, it is undisputed. Respondents admit they must comply with RLUIPA within the scope of their work as officers in a federally funded state prison. And this court has already held in Salinas that officers in a federally funded state prison can be held individually liable for misconduct that threatens the integrity or proper operation of the program, and that describes this case to a T. So RLUIPA is clear, it's constitutional, and we're asking the court to reverse. I welcome the court's questions.
So right after that statement, as has typically been the case over the last several years, Justice Thomas asked the first question, and he immediately questioned where was the support for these monetary damages of these state officials in spending clause legislation. And I think Mr. Tripp very wisely, knowing this court's interest in founding era history, said it goes all the way back to the founding era. And Justice Thomas really went further and questioned how his argument squares with a lot of current Supreme Court doctrine. Basically, how can you get from the spending clause to these damages sought, and whether the cases that Mr. Landor's attorneys had cited fit these facts to really bind these third parties, the third parties being the officials that are actually working in the prisons. And that seemed to be, again, just set the tone for the rest of the argument.
Yeah, it's even interesting to use that language, third parties, because in some ways we're arguing they're not a third party, that the attachment is, the federal government to the state. And as I think came up one time during the argument, the state prisons can only act through their officials, so that, that they should be bound by the statute. But that is where the court spent a lot of time just saying, can Congress bind the state, and they can, and does binding the state to follow RLUIPA include binding these employees, and what did they know, and what did they consent to? And that took up quite a bit of the argument.
So in addition, we had then Justice Alito coming in very early on to try to get a little bit better context of what happened here. And so we'll play this exchange between Justice Alito and Mr. Landor's attorney now.
Just out of curiosity, Did this prison shave the heads of all of the prisoners?
As I understand it, yes, that was the rule.
They shaved the heads. They didn't allow any type of even a short haircut?
I guess I can't speak to the length, but as I understand it, the rule across the board was everybody who comes in gets their hair cut. And I think it's really the paradigmatic example of the kind of inflexible and unyielding rule that Congress, in enacting this statute, was trying to get states to stop if they wanted to accept federal funds, that they needed to accommodate religious liberty.
If the language of RLUIPA was not clear enough to abrogate sovereign immunity in Sosaman, why is it clear enough to satisfy the spending clause?
I think it's really two answers. The first is, as Tanzin explained, and this Court has said many times, you always understand text in context. And the context of what's appropriate in a suit against a sovereign is very different than the context of what's available against an individual. This Court said this in Sosaman. It also said it in Tanzin. The tradition as to a sovereign, of course, is you don't get damages. But as to an individual, this is a tradition that runs all the way back to the founding. I mean, damages have always been available in that context. And so I think the context is probably the clearest answer.
That was an interesting part of the argument, and one of the few moments where, the court really showed concerns about the injustice, despite what they might find in this case as a limit to the statute's remedy provisions. I think it was, pretty stark to note that, and to know that in prisons now it is not expected that the state would have such an interest in, just routinely shaving heads like that. A later time in the argument that I also thought kind of, picked up on that same point, and it's good to hear the justices being concerned about what happened in this case, was when Justice Barrett wanted to know kind of what happened, that underscored the severity of the issue. Even if the monetary damages are not available, if the court should find that, she wanted to know what happened. Did the state take responsibility as it should? And the AG's representative said, he kind of was avoiding saying too much, but said the warden is no longer there. So, as we noted, though, mostly this was an intense argument about the text of the statute and the context of congressional authority. And I found that Justice Sotomayor was particularly helpful, really trying to clarify the distinctions between what kind of seeing the two sides of the court were getting to. And she, really, on a couple of occasions, really tried to clarify the issues. So let's play one clip about that.
I see the issues here on two levels. The first is it clear that an individual is bound by the statute? Is there an express cause of action? And that's clear. It says anyone can bring a suit against a government official or someone acting under a color of state law, correct?
Correct.
So the second step is it clear that the cause of action includes money damages? That's the next step of the analysis,
correct,
right? And your argument, I believe, is that Tanzin says that appropriate relief against individuals always includes damages. So does Franklin in a long list of our jurisprudence, correct?
That's correct. That's the traditional rule, is that damages are available unless Congress says otherwise.
So those two things are clear. So in terms of contract principles or causes of action, this is clear. Now, what our colleagues, and I think that was Justice Gorsuch's question, slightly different, which is, do we need to create special rules under the spending clause? Because generally speaking, if you're a prison official, you're working in a prison and you're bound by law to pay damages if you violate the law. Do you get an out because what? I think the consent question means what? Or notice and consent means what? And I don't know, meaning we're all presumed to know the law. When we take our jobs, the correction officers know he can't accept money. Citizens know they can't pay the money. We don't expect them to consent to that spending clause condition, do we?
I think one of the things that makes this case so much easier is that you have the consent of the person to become an officer in a federally funded program.
I agree, but I don't know why you need that. I think that's what you were saying, which is we never think of needing some express consent to say I'm bound by the law.
I really appreciated Justice Sotomayor here to bring some common sense into the argument, to again, kind of clearly lay out what we know, what is clear on the statute, and then at the end of the day to say, when people come to work, yes, we are bound by the law. As far as how much notice do you really need in order to know that when you go to work that you need to be bound by laws, including laws that apply to in the prison context, like RLUIPA, and that beyond this idea of needing to understand what damages might be, that we don't expect or require people to just to follow the law when they think they might be personally liable in some way, that we expect people to follow the law in their jobs.
Yeah, that's right. And then Justice Gorsuch kept pushing back, just saying, is it enough? Did the individual officials, know how they were bound? Did they have the right notice, and could they understand? And suggesting that they did not. And he emphasized that the circuits below have been deciding these cases against Mr. Landor's position. At one point, he was going back and forth. Justice Gorsuch was going back and forth with Mr. Tripp, saying, "I want to be clear. Congress imposed the condition on the person." That's what Mr. Tripp was saying. It's on the person. The state admits that there is liability at issue, and the remedy follows. And he said he kept on it. At one point he said, "And I'm not going to back down on that." To which Justice Gorsuch said, "And I wouldn't expect you to, Mr. Tripp." And there was that moment of levity in the courtroom there, where you kind of had this respect for just hard positions going back and forth on the court.
Yeah, and a number of the justices made similar arguments that basically said, look, all the lower courts, have ruled against you. Why shouldn't we? And that seemed a little odd to me, because isn't it the job of the Supreme Court, when it's necessary, to overrule or overturn what lower courts have done? And so that seemed like a bit of an odd posture for the Supreme Court to be saying, we're going to follow what lower courts have done, as opposed to saying, well, in light of what we ruled just 5 years ago in this other case, we want to make clear to all the lower courts that, no, they've been getting the law wrong, and this is actually what the law is. So that felt like a little bit to me like a little too easy way out for the court to rely, that they shouldn't overly rely on what lower courts have done when it's actually their job to tell the country what the law is.
Yeah, I think they're just trying to, slice this, very precisely, work out what are all the implications, how does this relate to their spending clause jurisprudence as a whole. But I agree, it was not as easy as we certainly would like it to be in following what the court had held before in the RFRA context. One kind of interesting issue on that point was that the SG's office supported Mr. Landor here, and earlier in that earlier RFRA case had taken a different position, and so there was a little bit of discussion about that. But the young attorney from the Solicitor General's office, Libby Baird, made her argument, said, we heard what the court said in Tanzir, and we follow that, and we're moving on. She just kind of didn't let it break stride and argued very aggressively, very rapidly, I would say. She was quite an impressive advocate who spoke very quickly, and there was no daylight, she said, really, between the position of the U.S. government, represented by the Solicitor General's office, and Mr. Landor.
Yeah, I also was impressed with her argument, and I thought, part of arguing before the Supreme Court, it's not just a rhetorical exercise, and you don't just need to know the laws and be able to answer the questions, but you're also, I think, one of the strategies is trying to make this feel like an easy case for the justices and an easy case on your side. And I thought in this particular exchange with Justice Kagan that Ms. Baird did an excellent job of making her side and her argument seem like the most reasonable one being argued in the court that day.
When you just said, Ms. Baird, groundbreaking, could you hum a few more bars on that? I mean, groundbreaking how? Groundbreaking what would happen? What would follow?
Sure. Well, I mean, I think petitioner's brief laid this out nicely, but there's sort of a long history of Congress being able to reach outside of the strict privity between the federal government and an entity that receives funds. I think all of that could be called into question. I think we've cited some sort of on-point statutes in our brief where employees or agents can be held liable. That's the Federal Nursing Home Reform Act, EMTALA, Title X. And then I think if the court accepts respondents' arguments on the constitutional issues, I think that could call into question Section 666, the bribery statutes, and Sabry. I think that this case is such an easy case because this case does not even approach the outer limit that this court has recognized in Sabry as permissible. And I think all the court has to do, the court does not need to extend Salinas and Sabry. I think all it has to do is cite those cases, say that no one has asked us to overrule them.
So again, Ms. Baird, arguing for the Solicitor General's Office of the United States, did a really good job, I thought, of making this case feel very clear. And of course, we could expect that the advocate on the other side would try to do the same thing.
So moving from the SG, the Solicitor General of the U.S. position, to the Attorney General's Office of the state of Louisiana, representing the state of Louisiana was General Aguinagua. And, you know, as expected, he really hammered on the positions of the lower courts about how they had found against this position. He argued that the Supreme Court should just follow those lower courts, and he really had to work very hard to distinguish a case that Mr. Landor had relied on, a case where the court had ordered damages from a so-called third party, an individual, to protect the federal government's interest. And in that case, it was about preventing fraud. It allowed recovery of money from an individual, not from the state itself, but from an individual. So that's the analogy for Mr. Landor. But Louisiana is, questioning, it really kept questioning whether Congress could use its spending authority to create what he called a substantive right that runs against an individual person in his individual capacity. And that's, really where a lot of the argument was. And as we'd expect, the justices want to push and see, where do things go? If the court goes this way or that way, what are the implications? So let's play a clip of an exchange between General Aguinagua and Justice Kagan.
Spending clause legislation, it matters because that imposes a bar of clarity that usually is not imposed. So when we read the statute, we have to be cognizant of the fact that it was passed pursuant to the spending clause, and we have to say, is this clear enough? But that doesn't have anything to do with the questions that you're now talking about, because once we get to this constitutional issue, we've already decided the statute is clear enough, and the question is only, could Congress do this?
So I respectfully disagree with that, Justice Kagan, for this reason, which is Cummings reiterated that Congress only acts legitimately when it sends federal funds out and it gets a reciprocal promise to comply with conditions in return. Sure, you can say that that existed here as to the state, but you cannot say it with respect to the state official in his personal capacity. One, because he never received—
Yeah, but that's what I'm saying. That's always true with respect to 1983 suits, is that you can always say, oh, the state understood this, but the state employees did not. Now, in fact, that's not true as a factual matter. State employees are well aware that 1983 suits exist and that other federal remedies exist too. But the point that I'm making is that this RLUIPA is no different with respect to putting an employee on notice than a 1983 action is.
And, Your Honor, I think if and when this court gets a Section 1983 action where the underlying substantive
We can strike that down, too.
No, I think you're going to have a question, Justice Kagan, about whether Congress could use its spending clause authority to create the substantive right that runs against an individual person in his individual capacity. That's not a question the Court has answered. I would say, if you eventually have to answer it, I think the answer is no, because that just is completely contrary to how this Court has conceived of the spending clause and the contract analogy that undergirds it.
I thought that exchange really highlighted not just what this means for Mr. Landor, not just what this means for other prisoners who are asserting religious free exercise rights, but what this might mean more broadly. What is the impact, not just for RLUIPA cases, but for other cases where government officers violate the constitutional rights of individuals? And that question is really relevant right now, Holly, when we see government officials across the country, many of them enforcing immigration action, violating constitutional rights of individuals in the exercise of their duties. And so I think this question is kind of front and center. A little bit of a distraction from the argument is Justice Gorsuch, a number of times, was trying to insert kind of off-base hypotheticals that had to do, for instance, with transgender athletes and athletics and abortion, to try to bring in other implications. I didn't feel like those questions really hit or permeated the argument very effectively. But I do think from a number of different angles, from I think both sides of the court, we saw that what's at play is not just what happened here in this case, but they're thinking about other statutes and other examples of action more broadly.
Yeah, and how they are tied to individual action under federal statutes that Congress passes. So after nearly 2 hours of argument, there are still a lot of questions. And while I certainly remain hopeful, I recognize that this is a hard case, at least to the justices. That's how it came across. But I was really especially glad that Mr. Landor was there, that he was treated with respect in the courtroom, and that these good arguments were made on his behalf. I got to speak briefly with Mr. Tripp after the argument and see Mr. Landor wearing his suit with his dreads grown down to almost shoulder length, imagining that over the last 5 years it's growing that back, and that he was certainly standing there dignified for his day in the court, his day in court at the highest court, and had a lot of support. And so that was a positive thing about the day. But it's definitely a difficult case. One of the quick reviews after the case that we saw that I thought was a fair summary was written by Amy Howe, who covers the court at SCOTUS blog. And she noted that the court looked at the claim very skeptically. I think it's a fair summary of what we heard. And we will certainly be following the case, be listening, watching for the court's decision, which we would expect by June. We'll put a link to that article in our show notes. And that brings us to the close of this episode of Respecting Religion. Thank you for joining us.
For more information on what we discussed today and a transcript of this program, visit our website at respectingreligion.org.
And learn more about our work at BJC Defending Faith Freedom for All by visiting our website at bjconline.org.
You can sign up for emails from us at BJC and Christians Against Christian Nationalism with the special link in our show notes. Using that link to sign up lets us know that you are interested in hearing from us about this podcast.
You can send both of us an email by writing to respectingreligion@bjconline.org.
You can find clips of this show on social media. We're at BJC on the Hill. And you can follow me on X, Blue Sky, and Threads at Amanda Tyler BJC.
And wherever you listen or watch, just take a moment and leave us a review or a 5-star rating to help more people find this program.
We want to thank you for supporting this podcast. You can donate to these ad-free conversations by visiting the special link in our show notes.
We'll be back next week So join us on Thursdays for new conversations respecting religion.